30 of these positions don't even pass muster on the anvils of Article 191. Forget 164. These are all the additional benefits. Salary, telephone, postage, travel within the constituency, travel within the state, travel outside the state, food and others, Century Alliance, HRA, car, fuel, electricity, water bill, furniture, vehicle, staff, medical allowance, use of helicopter. So 3 things will happen for those 30 people who are affected by 164 and 191. They will get the benefit of MLAs. They will also get the additional benefit of the cabinet rank position. Plus, they will also get emoluments from the appointments made. Because it's as good as saying, what cannot be done directly cannot be done indirectly. This is a mischief rule that has to be applied here.
So how many respondents are here?
You know, it's totally, we have implemented about 42.
Holders of the office.
Please, all the holders of the office.
How many?
Well, it's totally there are 48 respondents.
48.
Out of which what we have done is, I'll just show this 42. So all the 42 members who are the cumulative beneficiaries of the 9 notifications put together have been arrayed as defendants or respondents. So the first few respondents are the government of Karnataka, the Speaker of the Legislative Assembly, the Chairman of the Legislative Council, the Additional Chief Secretary to the Government, Election Commission of Karnataka. So from respondents 7 to 48 are the ones whose positions and who are the beneficiaries of these notifications, which is under challenge right now. So 1 to 6 are state bodies. 7 to 48 are the people in question. So entry number 1 of Hampanagowda Badarli from Sidarnoor, where he has been given the position of chairperson, Karnataka State Industrial Infrastructure Development Corporation Limited. Both 164 and 191 are triggered for this particular position. Can I just request my lords to kindly make note of this, because this will help my lords understand what the argument being made here or appreciate the argument better. Entry number 1 affects both 164 and 191. That applies to entry number 2, 3, 4, 5, 6, 7, 8, and 9. So from 1 to 9, 164 to 164 and 191 both are affected. That's our position. Then serial number 10, Shri N.A. Harris from Shantnagar, chairperson, Bangalore Development Authority. 164 is the only provision that is attracted because it goes above the 15% ceiling. Serial number 11, both 164 and 191. We'll present a comparative chart, but the net submission being 30 of these positions don't even pass muster on the anvils of Article 191. Forget 164. Even if someone is outside the scope of the bar under 191, but he's elevated to a cabinet rank minister, you could satisfy 191 and then be you can run follow 164.
Violate 160.
Exactly. So we are saying in some cases both have happened. In other cases, only 164 has been triggered because they've hit the ceiling of 15%. And since one of my central arguments, in fact, my primary argument of 191 has not even been considered by the previous bench in this judgment, my respectful submission is, to that extent, it is certainly per incurium. Plus, several judgments on 164(1)A have not even been dealt with. A matter of public interest which has a direct bearing on the amount that is going out from the public corpus or coffer, so to speak, cannot be killed on technicality is my humble exhortation. Can I just show one table from the petition to show what kind of benefits have been extended and how this is in the teeth of 164(1)A. I am not giving up my argument on 164(1)A because so many judgments on this point have been passed. It's right now, it's settled law, and even that has not been considered. With the deepest of respect, kindly come to para number 10 of my petition, where I've captured what are the additional benefits that a Karnataka minister gets under the Karnataka Minister's Salaries and Allowances Act of 1956. Serious discussion has happened before the 91st Amendment of the Constitution as to why this 15% limit was there. Because the history is, Milons, the Government of India Act of 1935 had a similar limit, which is the proto-constitution to the Indian Constitution of 1950. When we enacted Article 191 or rather 164(1)A, we did not have any such ceiling. Subsequently, the ceiling was introduced because people would keep accommodating people. In the process, the public was paying the price for it literally and metaphorically. Kindly come to paragraph number 10 at page number 15 of the petition. Does my lords have it? These are all the additional benefits. Salary, telephone, postage, travel within the constituency, travel within the state, travel outside the state, food and others, Century Alliance, HRA, car, fuel, electricity, water bill, furniture, vehicle, staff, medical allowance, use of helicopter. So three things will happen for those 30 people who are affected by 164 and 191. They will get the benefit of MLAs. They will also get the additional benefit of the cabinet rank position. Plus, they will also get emoluments from the appointments made to the state corporations.
So according to you, amongst the respond number 7 to 48,
Please.
there are appointees who, even if we ignore the
164.
cap of 163,
Correct. Correct.
4,
I'm
they
so
violate 191
91.
and in turn they fall within the mischief of this. Act.
Exactly. So the state act which exempts them does not kick into their benefit, and therefore 191 is immediately hit. That has not been addressed here.
So this 191 dimension is independent of everything.
My lords is correct. It's completely independent. It may have a consequential effect, but it stands on its own 2 feet.
And you are trying to plead that
30 of those positions
that
are hit by 191.
in fact 164.3 or what is 163.4, whatever it is.
Sorry, 164 1A. My apologies.
1A.
Yes.
1A. There you are will not be able to equate them with the cabinet rank because they are only conferred the benefit of cabinet rank.
That's exactly what I wanted to show, my lords.
So any judicial pronouncement on that line.
Please, please. There is a judicial pronouncement on the line that even if they have not been made cabinet ministers, but they've been extended benefits, then it runs foul of this. Because it's as good as saying, what cannot be done directly cannot be done indirectly. This is a mischief rule that has to be applied here. Because one of the purposes is, this kind of money cannot go waste for duplication of the same function. So the court has actually undertook an examination in the past to say, what is the nature of the function? Is there already a cabinet rank minister who's performing this function? Can you again make a secretary out of this particular function? Why do you need it? What is the consequence of it? My humble submission, that has not been dealt with. And it, of course, at the end of the day, the court's judgments are subject to the nature of assistance provided. And here, no such assistance has been extended to actually identify what is the discharge of burden that has been done by the state to address each of these points. On the face of it, there's a problem. So if there is an attempt on the other side to somehow pit me against the judgment of a predecessor bench, that's not the intention here. All I'm saying is those arguments were never made, and therefore the bench obviously therefore did not have the opportunity to consider those arguments. We are making those arguments. And this is in public interest. Can I just show some of the judgments on 164 1A to address my lord's question and conscience on what is the test or the rigor subject to which this question has to be addressed? Can I just show that for the court's benefit? Just a couple of judgments.
Senior Advocate J. Sai Deepak, arguing before the Karnataka High Court, challenged the state government's decision to confer cabinet rank and minister-like privileges on the chairpersons of boards and corporations who are not constitutional ministers. He argued that Constitution clearly limits the size of the Council of Ministers under Article 164, and the state cannot bypass this limit by creating shadow ministers through executive notifications. Granting cabinet rank is not symbolic, it brings real financial and administrative benefits such as official residence, staff, vehicles, allowances, and in practice, even access to state aircraft or helicopters. Deepak emphasized that this amounts to treating non-ministerial appointees as ministers without constitutional accountability, undermining democratic structure and separation of powers. He also highlighted the contradiction in the state claiming financial hardship to justify cutting welfare or opposing expenditure on helicopters for ministers while simultaneously extending costly privileges to dozens of political appointees. Such actions, he argued, violate constitutional discipline, fiscal responsibility, and the spirit of representative governance. More updates will follow soon. Jai Hind, Jai Bharat.